250 इसमें नोटिसेस को इश्यू लेने से तो इसमें ऑफिस नोट आया है कि रिस्पॉन्डेंट नंबर 8 को फॉर्म क्लोज हो गया है इसलिए वो आंसर नहीं, तो इसका केवल पेपर पब्लिकेशन किया
फॉर्म क्लोज हो गया है तो इसका क्या पेपर पब्लिकेशन,
क्योंकि उसमें एक बार अगर पेपर पब्लिकेशन हो जाता तो बस यही
क्या फॉर्म है, प्रोप्राइटरशिप फॉर्म है क्या?
जी प्रोप्राइटर।
तो फॉर्म क्लोज किसको बोलते हैं? प्रोप्राइटरशिप में प्रोप्राइटर इज द होल एंड सोल। प्रोप्राइटरशिप फॉर्म प्रोप्राइटर इज द फॉर्म क्लोजर से क्या मतलब है इसका?
ये एसआर पावर झारखंड लिमिटेड कंपनी है
Company is closed.
Yes, company. The office, as per the office.
The office was found closed or the company is closed?
Company is closed.
ऐसे नहीं होता है, आप आरओसी से उसको लाइए प्रोजेक्ट, ऐसे तो कंपनी इज क्लोज किसको बोलते हैं? वो ऑफिस में कोई नहीं होगा, ये कंपनी इज यू आरओसी से यू जस्ट हैव अ सर्च, you will get a report from ROC and then you can file appropriate petition.
From the supplementary list under heading for final disposal, item 1 WPC 2354 of 2019.
Compilation of the rejection. 2-3 provisions if you should put the place.
I have seen all the rejection orders, but they are not the same.
No, they are not the same. Therefore, in my comparative chart, which I have given the soft copy, I have mentioned the rejection. As for Tata Cummins, there are different rejection orders. 2 rejection orders are common, and other 2 rejection
there is
orders.
One rejection order which says that there is no provision for treatment of dental ailment.
Yes, and that we have given a reply that only because the agreement itself shows that with the hospital we have arrangement for dental treatment, there was no claim for dental treatment for that period.
So I will just search in the records.
So in the notes we have given
different impugned orders, different cases have different impugned orders, and there are different reasons.
Yes, Lordship, will have to hear the cases separately.
So yesterday you said that all is done, thus everything is same. In one of the companies I find, you see, in one of the impugned order I find that there was no previous exemption ever. So you said your primary argument was that exemption was being granted and then it was discontinued.
In the matters in which I am appearing, all those matters also there were exemptions for one period or the other. In one case, that will be
every case has a different
facts. Yes.
Every case has different. In some of the cases, there is only recovery proceeding which is under challenge.
Yes, one the first matter, so far as I am concerned, 6597.
Only the recovery proceeding.
Yes, because we have said my
exemption is
application
pending.
They are not rejected.
They are not rejected.
Very serial number 1. पहले तो उसी को करते हैं. एक-एक करके करना पड़ेगा. ऐसे नहीं होगा. ऐसे इस तरह से पूरा बैच ऐसे नहीं हो सकता. Serial number 1 done.
Yes.
This one, Tata Cummins.
Tata Cummins
सीरियल 1 में मेरा एक ऑब्जेक्शन ये है कि
नहीं निकालते पहले फाइल को केस नंबर बताइए.
Serial number 1 is
ये 2354 Tata Cummins.
2354. Yes. Mr. Das, it is your case. Your wakalatnama is there.
Yes.
Let us see what is the relief you are seeking.
In this case,
there is an order of rejection which
there
is
is an
under
order of
challenge.
rejection in this.
How do you say?
If my learned friend is appearing, there is a recovery. That is a different case.
कौन सा Mr.
6957
695
of 2016.
like 695 because these are that can be disposed of earlier because there is no impugned order as such.
But my submission is that today they can't be exemption. It has to be rejected. That's what my point is. And all these, I think that point is common in everything. 690.
This is,
I've sought for quashing of the demand notices.
when did you file your exemption application for each year?
Oh, the earlier application, the annexure one is for the 2011 verse 25 1
You give me
2011.
the date. The period involved is October 2000,
October 2000, no, period is in October 2011 to December 2014.
1.
And then January 2016 to May 2016. That is the period in the demand notice.
January 2016 to
To May 2016.
so in October, for October 11, where is your application?
Yes, that application is, if your Lordship has the chart, no, which Mr.
Oh,
Das
yes.
gave, in that chart, your
This
Lordship,
chart,
yes,
this
this
chart.
yes, this chart. We have given a composite so far as both the pieces are concerned. Your Lordship will take 6957.
6957.
हाँ है चार्ट में
इसमें तो 69 अच्छा नीचे है। It is not there.
it is can I just
Yes, please.
I just mark it first. I just
Page 36 to 39 पर
नहीं यहाँ chart. Okay, actually first two pages are the cases of Mr. Das and then they're just
I would like to see it on the records.
I will, but I'll just give an overview and then you should
That's
see the dates your options are okay. 6957, the first is date of application is 25/1/2011, year seeking exemption 2011, pending. Then again is 22/11/2011, date of application, year seeking exemption is 2012. 29/10/2012, year seeking application is 2013. 28/11/2014, the year seeking application is 2014. And I have been granted exemption in 1 year, that is 2016. These all are pending,
2016 you have been granted
granted exemption.
exemption granted 2016.
Have been granted exemption,
And these all petitions are pending.
pending.
But when you say that they have not processed your application on time and now there cannot be any inspection, no retrospective exemption can be granted.
Yes.
Correct? So you have to also show that you have made application as per the provision.
Yes, most certainly. And few, I will succeed for few years and I will not succeed for few years.
Like in 2014 you are filing in
Yes.
November
It is
2014.
related, 2011 is also, it appears to be related.
Yes. So far as 2012 is concerned, is it prior to 3 months?
Sorry, no. Now, there is only one way out when I argue this. Kindly come to section 87, the substantive.
Is it? Yes, I am. Section 87.
Section 87 is the appropriate government name by notification in the official gazette and subject to such conditions as may be specified in the notification, exempt any factory or establishment or class of factories or establishment in any specified area from the operation of this act for a period not exceeding 1 year and may from time to time by like notification renew any such exemption for periods not exceeding 1 year at a time. Right. Provided that such exemption may be granted only to employees in such factories or establishments, otherwise in receipt of benefits substantially similar or superior to the benefits provided under this act. Provided further that the application for renewal shall be made. Now, kindly note, this is only an application for renewal shall be made 3 months before the date of expiry of the exemption period, and a decision on the same shall be taken from the appropriate government within 2 months of receipt of such application. Now, section 88 is a different thing. Section 90 mirrors is another thing. Section 91 may be important. It is again which says exemption from all the provisions of the act. But 91A, any notification granting exemption under section 87 may be issued so as to take prospectively on such date as necessary. So today, brothers, whatever period I had applied, number one, that 3 months bar is for renewal. Having not granted me a reading together, brothers, even if it clearly, to be fair to both sides, I have to make an application beforehand. If I'm seeking 2011, I can't make an application in 2000. I have to make it in 2010 because they also need some time to reasonable time to process it. And once they decide to grant me, it will have to be prospective. So all these years where the application is 3 months period is for only for renewal, but to be reasonable, that can be borrowed in for a fresh application as well. That your lordships dates we have disclosed. Where it can be granted, where it cannot be granted, is a matter of your lordship's decision now in view of this example. But to keep it pending for all these years, and having regard to the fact that there is no dispute that I have given services or benefits to the employee, that in view of Jardine Henderson, your lordships can keep in for equity's sake, not insist on payment for those services, or come up with some moderated payment.
What do you say to this?
So my first is each year's application is a separate cause of action. There cannot be clubbing of cause of actions in a writ application.
You see, those.
So this is my first technical objection to the.
This case has been admitted.
These
No.
are under admission.
It's not a question of this because here there is no rejection, there is one demand. You have raised one demand, I can't find 4 writ petitions.
Anyways, now they are not technical, please let them address it.
So my first is I have raised a demand because of non-payment of the contribution.
You have also raised a consolidated demand.
I can raise a consolidated demand for the reason exemption has to be decided year-wise. If exemption
So
is
no separate demand notice.
no separate demand every year
So
is to
they
be
have
issued.
also not filed a
Lordship,
separate.
but exemption for each year's exemption, as I've already pointed out, each year's exemption is a separate cause of action. Rejection is a separate cause of action. Each exemption has to be decided on its own touchstone.
You see,
That's
each year you have not processed it.
Lordship, it
For
has not.
every year they will file a separate petition.
Lordship, this is why I'm saying so, because it would be
Anyway, this objection is rejected.
As
What
your
do you have to say on merit?
on merits. Lordship, the aspect is exemption application is pending. Under law, no employer can say that exemption application is pending and deny contribution payment.
Deny?
Payment of contribution to the ESI. It is as good as saying that my application is pending, I won't pay the statutory duty which is encompassed under the Act.
No, I don't get it. You see, you say that
Contribution,
retrospective exemption cannot be granted.
definitely, Lordship.
The application is pending.
Application is pending,
You do not process it.
it is not processed,
Not processed.
not processed,
And ultimately the period is over.
it is over.
Yes.
Lordship,
So
then who is to be blamed?
you have to be blamed.
Lordship, it is
You
not
could have
us.
rejected it.
It is not us. It is both the parties. For the reason, 2011 matter, they are raising in the year 2016.
Because you have raised the demand. in
Lordship,
2016.
I've got a period of 5 years. In 5 years, I can raise a demand. Now, contribution and exemption are two different things. Contribution is a statutory duty casted upon the employers to do this. Exemption is a form of exception. So, exception has to be understood in the same manner as an exemption which is required to be understood for the reason that they have to be very particular to get it. If they are not, the contribution has to be there. Because it's as good as saying that I filed a appeal and I should not be made, I should not be subject to payment of the entire amount. So this is not the case. Contribution is there. Contribution is the mandate of the statute. Exemption is an exception to that. So he has to see there's no exemption order which has been granted. For whatever reasons, he was not diligent in pursuing the application. The application could not be processed because ESI and state government are two different entities. Contribution has been demanded by the state government, by the ESI. Exemption is to be decided by the state government, a separate adjudicative authority.
So they have filed their application for
Before the
exemption
state
before the
government.
state government.
Before the state government. If they are not processing it for reasons best known to them or the concerned authority, the statutory mandate of payment of contribution cannot be given a side because this is a beneficial piece of legislation.
And this amendment has come up from.
In the year
Yes.
2010.
In the year 2010. So these periods are covered except for in one case, but it will not cover. That is of the case of Tata Steel utilities and infrastructure.
Just a moment, let me capture this. WPC number 6957 of 2016. The learned counsel for the petitioner has submitted that the respondent ESL has raised demand for the period from October 2011 to December 2014 and January 2016 to May 2016. But the application for exemption for the year 2011, 2012, 2013 and 2014 remained pending from 25/1/2011, 22/11/2011, 29/10/2012 and 28/11/2014 respectively. The period January to 5/16. You have said that exemption for the period 2016 was granted,
Yes, 2016 has granted. I have to.
but that demand is also there.
Yes, they have made a demand from January to May. I'll just show the 2016 order. Sorry, annexure 9 kindly come to page 17. In 2015, is that? Exemption. Just sorry, just. Because in my rejoinder, I'm so sorry,
The state
there's a statement.
election.
If your lordship can just give the documents, page 9 of my rejoinder. Why did I just clarify that what they have done? I have actually been granted exemption from 16/8/2016 and 17/12/2016. That's the period of exemption. That always counted.
The learned counsel has submitted that exemption was granted with a hearing notice, received favorable order. What is the period is not there.
This was here,
On the left side.
16/8/2000. Here, I mean, hearing, we see fair granting.
Date of hearing.
Hearing. That is not there. Now just keep that blank from what I'll get that date. So I will also.
The learned counsel has submitted that since the applications for exemption was pending and the same was not processed, the demand is itself bad enough.
And that is the reason for what in the review, page 77, your lordship says. The reason for this is 91A. The impugned order in page 77 under 45A.
Yes.
Kindly come to this third last paragraph, whereas Sri Natarajan appeared before the undersigned on 3/10/2016. However, he did not produce any records required for determining the dues of ESI contribution payable by the company for the periods mentioned in notice dated 15/7/2016. Instead, he again submitted letter number so and so dated 3/10/16, reiterating the same facts as already submitted before the undersigned today's letter dated 16/8/16. He was again intimated to Sri Natarajan that there is no provision in ESI Act under 1948 under which the order relating to grant or otherwise of exemption of a unit can review by the state government who had issued the same. It was again intimated to him that as per section 91A of the ESI Act, no order relating to grant of exemption can be issued retrospectively, and therefore the petition of exemption filed by the company for the calendar years 2011-2014, in respect of which no orders have been issued by the state government, have become infructuous. At this stage, she so did not show any inclination to produce the records for assessment of due of contribution payable by the company for the period mentioned in the notice date so and so. Accordingly, the undersigned is having no other option but to proceed with the case on the
The
basis of
learned counsel has referred to the impugned order as contained in Annexure 10 at page 77 and has submitted that as per the impugned order, by raising the demand, it has been intimated to the representative of the petitioner who was appearing for the hearing that as per section 91 capital A of the ESI Act 1948, no order relating to grant of exemption can be issued retrospectively, and therefore the petition of the exemption filed by the company for the calendar year 2011 to 14, in respect of which no orders were passed by the state government, had become infructuous.
there is a submission. I have got notes. If your lordships master can give the records of WPL 3900 or 2021. Serial number 10. There in the rejoinder we have annexed the notification of exemption.
The notification of exemption granted
For
for
the
the
period
period 2016,
1/1/2016 to 31/12/2016.
for the period 1/1/2016 to 31/1/2016 has been annexed in WPC number
3900
WPC number 3900
of 2021
of 2021 at page
56 of the rejoinder,
56 of the rejoinder.
which was interestingly shows that the exemption was granted to me for that period on 9/6/2017.
And he submits that the exemption was granted by order dated 9/6,
Notification,
by notification dated 9/6/2017
17,
for the period 1/1/2016 to
31/12/2016.
31/12/2016.
They have not challenged this, they have accepted this. Because this, according to me, is also
In such circumstances, he submits that mentioning that the case that the exemption applications have become infructuous is contrary to their own conduct, as the exemption for the period 2016 was granted by them by the state government in the year 2017. ये 2016 का part period कैसे आ
हाँ
रहा
ये
है?
देख लीजिए, हम दिखा देते हैं जो ऑर्डर है.
This impugned order is not for the year 2016.
I will show kindly.
It is only from 2011
Now,
to 20.
no, we had a mistake. Not demand notice जो है, it is supplementary affidavit brought on record. Supplementary affidavit filed on December 2016. That is 8th December 2016.
But so far as Annexure 10 is concerned, it is for a particular period 2011
To May
2014.
14.
To 2014, it is
नहीं
not,
वही कह रहे हैं. उसके बाद supplementary affidavit Annexure 10 page 4.
that's not under challenge.
That is 1310. वो actually they had
Yeah,
given a
that's
corrected. So what they had done is in my supplementary I have brought on record the complete set of demand notice. Actually, incomplete set get filed. Therefore, the complete set are by supplementary. That is what my supplementary. नहीं इसके बाद with the characters mistake. This page missed out. We missed out one page in between. Supplementary. We missed out the page.
Second page was missed out.
Just a moment. It's indicated the notification granting exemption has been brought on record at Annexure A. इसमें तो है
अच्छा. Counter.
Annexure A to the counter affidavit dated 7/9/2018 at page number 30,
Yes, sorry.
which is for the period 1/1/2016 to 31/12/2016, while notification dated 9/6/2017.
Now, the period for demand which you are expressing is at page 5 of the supplementary affidavit. We missed out.
Same, no. This period of demand. The learned counsel submits that the complete set of impugned order dated 13/6/2016 has been placed on record through supplementary affidavit, whose second page reveals that the demand was for the period from October 2011 to 12/2014, and then from January 2016 to May 2016. ये अक्टूबर बीच में कैसे आ जाता है?
हाँ यह नीचे.
Why this October? Mid of the year.
5 years. I want a 5 years limitation.
Commencing from October 2000. Yes. So I defaulted in
The period of default has been shown from June 2011 to May 2016.
Now another thing you should note, why you is asking why is January 16 to May 16 included? Because this demand has come on 13/10/2016, that is before the exemption was granted. So on 13/10/2016 there was no exemption notification. That's the reason.
So according to you, this amount for the period January
January
2016 to May 2000.
Should be.
The learned counsel submits that in view of the exemption granted for the period January 2016 to December 2016, the demand relating to this period amounting to rupees 5,04,075 anyways is not sustainable in law. Correct?
Yes, it's 504.
Oh, very good.
So 504.
504,075.
The only further submission in response to Mr. Anand's argument is 1 minute.
No, there is one more thing I want
Yes,
to
explain.
show it to you. Your application seeking exemption.
Yes, that are, those are.
Just have a look at it.
Yes, fine. Annexure 1. that is
Your case is that whatever is there in Tata main hospital is being provided.
Oh, yes, yes.
Everything.
Yes.
That is there, your specific case,
Specific case.
right? And then you have also referred to your rules and regulations, whatever is applicable.
Yes, whatever is applicable. I have also brought on record a supplement, union. Union has filed a letter which I brought that we are also satisfied with the.
So their satisfaction is irrelevant.
No, they are also stakeholder.
Maybe they are stakeholders.
Just supporting that the workers.
That's it. You see, you have these service rules and conditions that you have.
The benefits.
Maybe that the inspection cannot be done now.
Correct.
But whatever benefits are there, they are on record.
But that is evident from the fact that in 2016 you considered same benefit and granted me exemption. How these standards, therefore, in 1 year, same benefits. The only exercise they can undertake today is that whether.
Now we have to also see
Fine.
that so far as Tata Steel's case is concerned,
Yes,
that is directly related to TMH.
yes.
Was Tata Steel granted any such benefit with respect to TMH for this period?
2016, yes.
If that be so,
Hmm.
if that be so, then there can be no reason for any separate inspection for these people.
Not, but the benefits they will have to see. But Tata Steel and Tata Pigments gave the same other benefits. Then maybe
Yes, so
side-
far as other benefits are concerned, I
But
do not
hospital
know
also-
whether it is same
Yes,
or not.
that I understand.
Because we have a batch of cases. If Tata main hospital facilities
Right.
and whatever is being provided through Tata main hospital, if it is applicable for them
It's applicable for us.
and if it is available for Tata Steel for a particular 2011 maybe, then can it be said that the same facility being provided to a brother or sister concerned, they are deprived of?
No, it can't.
I do not know.
No, it
Because
can't.
Tata main hospital, they say that they are also entitled to other facilities. Are they also entitled?
Yes, same,
At least
same
that can.
benefits.
They are
So
different.
no
I
fresh
got it.
inspection would be required
No fresh inspection would be required.
because hospital is the same.
And once additionally, which is not on record but clear cut, I have also been granted exemption for the current year till 2028. So they can always see what is the benefit I am giving exemption for today and what was there earlier.
What was there earlier?
If the
So,
same
so
benefit.
if these particular terms and conditions, whatever you have now,
Yes.
if it was there even at that point of time,
Yes,
so
I-
terms and conditions cannot be a matter of dispute.
It cannot. It is all documented. So all benefits of our service rules are documented. They can see, and your worship is
You
right.
can see.
I forgot that part. If TMH is good for Tata Steel, then TMH, if same benefits,
Yes.
is good for Tata Pigments.
So they cannot say that they cannot say that it cannot be examined.
Oh yes, of course, it is all papers based. It can be done.
They say that it cannot be given retrospective, that we will see, but you cannot say that it cannot be examined.
But as 100%, they may fix a date. Will appear, and we will show them that how 2011 and 2026 for a moment are similar of 2016 and 2015 were similar. Because your state government has said that 2016 exemption is granted. If I am able to show a parallel for 2015, 14, then your worship
With identical terms and conditions.
identical terms and conditions, then your worship can take a view at a subsequent date that whether or
And
not
what was your arrangement with Tata Steel? Because
they will give it.
what was your arrangement? There is also a catch here.
Yes.
You have an arrangement with TMH, right?
I know.
Okay, you can go to TMH and have your whatever
Cashless.
redressal and
Yes,
treatment and
yes,
everything.
yes.
But do you also have a treatment with tie-up? Do you have the same facility of tie-up, etc.? That may not be there.
No, that tie-ups also must be minutes.
We do not know. We do not know. It is not here.
Yes, you should be right. I cannot even show, but I can show. But I can. They can very well.
We are not here to see those.
They can show whatever.
They can see whatever they want to see.
100%.
If the employees are identically placed or they are not identically placed. See, in taxation also there is no concept of res judicata.
No.
But still, if a particular view is taken for a particular period, that has a very serious bearing. There is no concept of res. Similarly, there may not be any concept of res judicata as they were doing. But the point is that if a view is taken with a particular facility for a particular period, for a particular establishment, they cannot have it their own ways in every year and say there is no restrictive
The officer, change in officer will not decide the change in person. That's my concern.
So this is it so far as.
Yes, I am happy to go back to them, show to them, and then be satisfied that they satisfied.
What is in sequel to this? You place the case of TMH. Tata Steel.
Tata Steel.
Yes.
Tata Steel Works WPC 2536.
One of the reasons that given is that there is no facility for treatment of tooth. One of the reasons I saw that. Where is the Tata Steel's case?
Tata Steel is verse 2536.
So this covers your, just a moment. एक second. इसको भी
हाँ, इसको तो एक ही
एक
case
second.
cover.
The learned counsel for the petitioner has also submitted that as per the application seeking exemption, the petitioner is the employees under the petitioner are entitled to all the benefits of hospital and full medical arrangement as is available in Tata Main Hospital as per the arrangement between the petitioner and Tata Steel Limited. He has further submitted that the terms and conditions of employment with respect to various facilities was also placed on record before the authority in a tabular form. Further, it is not clear from the records as to whether the employees of the petitioner have the same benefit of tie-ups. You have tie-ups now.
Yes,
Tie-ups with other hospitals as may be applicable for employees of Tata Steel Limited. That arrangement between the petitioner and Tata Steel Limited can certainly be examined by the authorities. Right? So far as the case of Tata Steel Limited is concerned, the same is also involved in this batch of cases. They who avail the facility from Tata Main Hospital. The learned counsel submits that if the facilities in Tata Main Hospital for a particular period for one of the petitioners in this batch of cases is sufficient, then there can be no reason that the same facility being extended to the petitioner of the present case be denied. The learned counsel for the opposite respondent ESIC has submitted that the application for grant of exemption is filed before the Commissioner and Secretary, Department of Labour and Employment, State of Jharkhand, Ranchi, and the organization ESIC is entitled to receive the amount unless exemption is granted. Exemption is not a matter of right, it is an exception, and in absence of an order of exemption, there can be no relaxation in favor of the petitioner.
And one more.
Mere filing of an application seeking exemption is not sufficient. The exemption is required to be processed and granted, and for that, ESIC is not responsible. The petitioner has clubbed different years right from 2011 onwards, but has not taken any steps with respect to one or the other year for process of their exemption application. This ESIC comes under the Commissioner and Secretary, Department of Labour and
This is an
Employment.
independent entity.
Maybe independent entity.
We-
Does it come?
It does not practically come down because
Practically नहीं. Other hierarchy में क्या
नहीं,
position?
hierarchy में ये तो state government हम लोग corporation हो गए of the by a central
The
status.
copy is also being sent to you.
It is also marked because we have to appear we have to contest the exemption application.
So you are also aware that exemption.
Exemption is
Yes,
definitely,
yes.
yes, we are.
During the course of hearing, it transpired that the copy of exemption application was also forwarded to the regional director ESIC as well as inspector/manager ESIC with intimation to them so that they may also appear before the authority in the matter of hearing on the point of exemption.
So far as prior number 1 is concerned, in my humble submission, does not enable in view of the alternative remedy. He has got a twofold remedy, 45AA under the SI Act, challenging the same. Thereafter, section
45
AA.
Okay.
And
Then?
after section 75 of the SI Act, he can go before the labor court. Exemption, there cannot be joint of cause of actions. Because exemption is a separate, contribution demand is a separate.
The learned counsel submits that the petitioner has two alternative remedies which he has not availed. One is an appeal under section 45AA against the demand raised, and so far as section 75 of ESI Act is concerned,
it will go before the ESI court, which is the labor court.
the 75.
75 1G.
75 1
G.
within bracket G is concerned. If any dispute arises, the person who is or was the principal employer in respect of an employee may approach the labor court for adjudication of this.
Employees insurance, state insurance code, EI code. The term is EI code.
Achha, labor court, ESI court.
Matters. Labor code को power दिया है, but हम लोग जब भी लिखते हैं ESI code. Not just one document from his petition.
Yes.
And your 4 series is also my reply
Where is that?
from page number 50 onwards.
$50 of your counter.
Net application, they have annexed it.
50. Yes.
So these are the replies submitted by the SI Corporation before the Department of Labor.
Okay. So,
And apart from the comparative chart, Lordship would kindly permit me 2, 3, 4, 5, 6, and 5 would also.
just a moment. The learned counsel for the respondents has also referred to annexure 4 CDs from page 50 onwards that these are the objections raised by ESI C before the Principal Secretary, Department of Labor, Training and Employment, raising objection with respect to the claim
Exemption applications.
of with respect to exemption application filed by the petitioner.
And Lordship, just one additional, 5th, Lordship may turn this next page, para 5. There's an additional thing which was incorporated over here.
He has specifically referred to paragraph 5.
2, 3, 4, and 5. 5 is an additional thing which 5 is in case of a medical college having been formed, the wards of the insured person are eligible for admission under the SIC management quota.
This is on merits. Why
On
should-
merits. And Lordship, just to support his case, that additional is pending, it can be decided by the in my compilation, Lordship, at page number 59, my compilation. In that case also, the matter was sent, para 30. Was sent to be determined by the state government. The extra argument was sent for determination, para 30.
Page number 59.
Page 74.
Page 74.
Honorable Bombay High Court notes. Exemption state.
Para number?
30 at page 74.
Can you read it?
It is seen that petition was admitted, no interim relief was granted. Petitioner also did not pursue the application for exemption. On the other hand, government declined to consider the application in view of the pendency of this petition. It is not clear as to whether the employer and employer's contribution was deposited with the ESI If it is reported, it is well and good. However, if it has not been done, it creates a situation of interest of the corporation being jeopardized, which will ultimately affect the large number of beneficiaries of the corporation, naturally including those who are governed by the BD industry. This court is therefore of the view that the government will consider the application for exemption. The same shall be decided as soon as possible within 3 months from the date of receipt of writ. If government finds that the writ petitioner who is applicant before the government is not pursuing the application, it needs to state that the state government would refuse to decide the application. So we also there is application was pending. The honorable court directed for deciding the exemption application.
So your applications are, their applications are to be decided.
So I'm just supporting his case. That's what I said.
Would that one submission also be recorded notes that the benefit of whatever benefits we were providing, good, bad, ugly, were given to the employees and during the period when
The learned counsel for the respondent has also
It starts from page number 59.
referred to the judgment passed by Honorable Madras High Court. In the
Bombay.
case of Bombay High Court.
Bombay Malus, MH.
Okay, Maharashtra.
Maharashtra.
Maharashtra, on Bombay
Nagpur
High
bench.
Court,
Nagpur bench. But
Nagpur bench in Ramchandra Omkartal Agarwal versus Union of India versus para number 30, and I submitted that in the same case also the application for exemption was pending and the matter was remitted to the authority for deciding the same as well. That's it. We had in one more case, we had remitted the matter for decision.
check up.
What the learned counsels,
Must have.
That's-
Your Lordship, permit for 5 minutes. If your Lordship permits, can I just?
should I disclose it off?
Your Lordship, yes, your
This
Lordship
matter-
will protect me till the matter is decided by them. That,
I fix a date.
yes, we'll appear on that particular date with all the documents.
An upper limit of time. There's a 3 months, whatever.
वो तो I have to. I have to.
Can I have your Lordship's permission
sure.
to come?
After hearing the learned counsel for the parties. It is not in dispute that the application seeking exemption for the period 2011, 2012, 2013 and 2014 remained pending before the authority, before the secretary, before the Commissioner and Secretary, Department of Labour and Employment, Jharkhand State Branch. For the from 25/1/2011, 22/11/2011, 29/10/2011, and 28/11/2014. And admittedly, exemption has been granted for the period 2016. In the year 2017, for the period from January 2016 to December 2016. In the meantime, the impugned order has been passed by the
Employee State Insurance Corporation officials.
by the ESIC dated 13/10/2016, raising the demand for the period October 2011 to December 2014 and January 2016 to May 2016. By observing that the cases which have been the matters seeking exemption for the period 2011 to 2015, 2011 to 2014 had become infructuous. The records of the case reveal that notices were also issued to the Regional Office of Jharkhand Employees Insurance Corporation as contained in Annexure 4 series.
बस झारखंड डिलीट कर दो
Sorry, regional of इसमें लिखा हुआ है Jharkhand Employees State Insurance Corporation. It is mentioned in the letter.
Regional office Jharkhand. Regional office Jharkhand is
Okay.
separate.
Regional Office Jharkhand of Employees State Insurance Corporation, Nagpur branch. With respect to some of the periods and the copies seeking exemption, the copies of the exemption application was also forwarded to the Employees State Insurance Corporation, Nagpur branch. It is further not in dispute that these applications were filed. This court is of the considered view that the applications having been filed before the Commissioner and Secretary, Department of Labour and Employment, State of Jharkhand, Ranchi, who is the competent authority to consider the application, the Employees State Insurance Corporation, by raising a demand, could not have stated that the applications have become infructuous. Once an application seeking exemption is filed, the matter is required to be taken to a logical end, and it has to be examined, and it is for the adjudicatory authority concerned who has to take a call with regard to the fate of the application. It will certainly be open to the authority to take every aspect of the matter, including the provisions of law, and examine as to whether the parties have acted as per them. But the matter having been pending before the adjudicating authority, the ESIC could not have said that the matters have become infructuous. In view of the aforesaid facts and circumstances, this court is of the considered view that the impugned demand dated 13/10/2016 for the period October 2011 to 12/2014 and January 2016 to 5/2016
Yes, the demand will be kept in abeyance. It cannot.
yes, would not have been enforced through the impugned order. It would be suffice if the aforesaid authority, namely Commissioner and Secretary, Department of Labour and Employment, State of Jharkhand, Ranchi.
Now respond number 2.
Now respondent number 2 is directed to decide the pending applications.
If not decided, because update position we are not sure.
What do you mean it not decided? State is here.
Pending decided.
In such circumstances, the petitioner and who will appear?
The officials of the ESIC. Because we don't know.
And the concerned officer of the ESIC are directed to appear before the respondent number 2 on 8th of July 2026 at 11 AM with their relevant records and the said authority shall decide the applications seeking exemption in accordance with law, taking into consideration the provisions of particularly taking into consideration the provision of ESIC Act, and pass a speaking order within a period of 6 weeks thereafter, and communicate the order to the parties through speed post and also through email, which may be email ID, which may be furnished by the parties to the aforesaid authority. It will, in order to ensure that there is no gap, the authority may call upon the parties to file their written submissions. You file your written submissions also.
And
whatever
it is
you
kept in abeyance till
Yes. The impugned demand dated 13/10/2016 shall be kept in abeyance till the final decision and subject to the result of the adjudication. Timeline is going to be a huge problem. कोई बात नहीं. इसीलिए एक्ट में 3 महीना के पहले नहीं की मुश्किल. Anyways, this goes
definitely not.
TMH वाला कौन सा है? इनके साथ this was the only case you went at.
There are other cases, but pending is perhaps only one. Pending is case.
Where is the case of TMH? क्योंकि इसका direct link है उस.
पेंडिंग केस सेम इसमें एप्लीकेशन पेंडिंग
एक ही है. और TMH टाटा मेन हॉस्पिटल का टाटा स्टील लिमिटेड का
After such a state. 2668, those are bites.
ये कब किस पीरियड का है ये?
पासपोर्ट दिस केस में
अरे भाई फाइल तो खोलिए.
for the seeking exemption for year 2022 2668. We are seeking the
They were granted exemption prior to that.
yes sir. In 1982 to 2000 they had granted exemption.
2000.
We have made a chart for
Where is that?
address. Chart is also the date of application.
Two 668. Granted exemption for 2015 and 16.
I've just given a chart. Serial number 10.
I think I have this. The same thing.
Serial number 10.
It's the same thing.
2668.
2668. Yes, इसलिए वापस करें. Yes, what is this 2668?
Date, kindly see the third column, that is date of exemption, seeking exemption. That is 2022. The next column is date of rejection of the order. That is March 5, 2022. And the next column, the last column is exemption granted.
Okay.
So in that column, 1982 to 2000, I mentioned also. So I have given the details.
1/9/2014 to 7/8/2015. Then 8/8/2015 to 7/8/2016. 2011, 11 to 14,
11 to 14.
जिनका इनका पर्टिकुलर का केस 11 to 14 में आपको एग्जामिशन नहीं है.
नहीं, इसमें as per this chart we also 11 to 14.
Not there. Correct? As per this chart,
It is
11 to 14 is not there.
14 to 15 is there, or 15 to 16, 16
Yes,
to 17.
11 to 14 is not there. What
Yes.
happened to 11 to 14? What happened to 11 to 14? It has been rejected. 1/5/2010 to 1/8/2013. It has been rejected. By order dated 10/10/2013. There is another petition 7033 of 2013. ये जरा देखिए 7033 of 2013 का status. 7033 of 2013.
Uh, 13 for the year 13-14 it's still pending. This one, the officers are for 13-14.
तो आपका ये आपको तो मिस्टर आशुतोष जो अभी डिस्पोजल किए हैं टीएमएच का आपका एग्जेम्पशन नहीं आएगा सीधे रिजेक्ट करना.
I'm sorry.
You see, they are related to TMH.
May I just clarify one small aspect? TMH only provides for hospital in-house treatments.
Yes.
The benefits which we provide and the comparative analysis apart from dental are with regard to service condition the benefits. तो वो चीज है. तो hospital treatment में कभी except for that dental treatment, there is no other comparison vis-a-vis the hospital treatments are concerned. The only कि TMH में dental treatment नहीं था. This is the only addition. Nothing else.
Pending.
Where is this 7033 of 2013? Pending है कहाँ pending है?
Pending.
7033 of 2013. There is a stay in that.
It is fixed on 7th July. Before the division bench. Before the honorable division bench.
Yes, DB का मैटर सिविल के यहाँ नहीं होगा
DB का
DB में 7 जुलाई को है ये मैटर
yes sir.
क्या बोलना है आपको इसमें बताइए क्या बोलना है what do you
My
have
lord,
to
in
say?
that 7033, they have challenged the virus from 91A.
Okay.
जो amendment was challenged.
Yes, what do you have to say to this?
Only for this case of one focus.
देखिए ऐसे नहीं होता है बीच में केस छोड़ के गए हैं तो
Since we are understanding it's really चले जाता है we are under the impression-
seriously it is linked directly linked to this अच्छा चलिए
So
seriously
series that's why the impression is really
सभी तो चले गए यहाँ से मैडम आपका कौन सा केस है you argue your case which one is your case third one चलिए इनका फाइल अननेसेसरी मेरा भी तो 20 मिनट बर्बाद किया आप खड़े होकर कुछ आता नहीं है तो क्यों खड़े होते you do not know anything about the file you should have said that you do not know anything about it don't do this again नहीं करना है मत there are many other councils who are waiting to do their respective cases कौन सा serial number बताइए भारत Caterers right
date and
right
and exemption rejection order and the chart which was given comparative chart of it. More or less it is it rests upon the case of Tata Motors because
ऐसे नहीं होगा मैडम इम्प्यून ऑर्डर दिखाइए
yes
show me the immune order
it's an extra 25 page 131.
131
Before that, after reading that, I will give some facts. Before
131 is short recital of the case.
131, page 131.
Annexure 25.
I've given with a written note.
The अच्छा you have put it here
हाँ, वो लगा दिया और comparative chart.
हाँ बताइए where is the order
कार्यालय annexure 25. Last.
yes
कर्मचारी राज्य बीमा अधिनियम 1948 की धारा 87-88 के अंतर्गत नवंबर 2015 से अक्टूबर 2016 तक के लिए मेसर्स भारत कैटरर्स जमशेदपुर के विमुक्ति के आवेदन पत्र को निम्नलिखित आधारों पर अस्वीकृत किया जाता है। मेसर्स भारत कैटरर्स कंपनी अपने कर्मियों को चिकित्सा सुविधाएं केवल टाटा मोटर्स अस्पताल के माध्यम से ही उपलब्ध कराता है एवं इसका अपना कोई मेडिकल इंफ्रास्ट्रक्चर नहीं है और न ही किसी प्रसिद्ध अस्पताल से टाई अप है।
just hold on this tie-up is an important issue so you don't have any tie-up
I'm coming to that. Whatever the medical facility is given to the employee, principal employee Tata Motors, they are working in the hospital itself. They supply the food to the patient and other staffs and all the medical facility which is given to the employee of Tata Motors that is provided.
so
to them.
what kind of arrangement do you have with Tata Motors
With Tata
you are a contractor
yes.
and suppose the contract is over then what will happen
There is a tripartite agreement and since 77 they are working and now all the employees of that period they have retired in the year 2024 and still that canteen exists from 77
it may be 77 years maybe 100 years but the
And all-
point is that there is a renewal of contract from time to time
time to time.
right suppose the contractor changes what will happen to these employees
Till now it has not been changed. They have
till
retired.
now it
Yes.
might not have
And
been
now
changed.
under ESI scheme we are now that issue has been over because we are depositing the ESI the amount of ESI under that act ownership.
You are depositing it. Since when? Since when are you depositing?
Everybody, Tata Motors, Tata Steel, everybody, all of them have started depositing now. I'm
That's
giving it. So they have retired, and so that issue doesn't remain. Still, it is there.
Since when have you started depositing them?
Depositing.
Since when are you requesting?
May 2017.
Since May 2017.
Regarding Tata Motors, all of the employees, they have crossed the minimum limit of salary. Now the salary has exceeded, so that thing is also.
21,000.
So I'm still there, existing there. Now second
Do
point.
you have the tie-ups?
Yes, I have all the tie-ups. I'm show the letter of the concerned department of Tata Motors which they have addressed. I will show that. That is
What's the
next.
Where's it?
That is annexure 28 filed with the supplementary affidavit filed on 30/4/2018. और इनका यूनियन का भी लेटर है. They also filed for exemption. That is. I think that will make a concern or not, but they have given all the details that what benefit they are getting, whether there is a tie-up or not. The union representative have also given. That is page 28. Sorry. Annexure 28. To Bharat Caterers. Then I will read the letter of the union representative also.
You see, the point is that you say that there is tie-ups. Right? Don't show me from the letter. This is the impugned order, no? You must have attacked the impugned order in your writ petition itself. This is the reason given in the impugned order. Supplementary letter से क्या होगा? Impugned order as a whole, every ground is to be attacked in the writ petition itself.
The petition have stated that whatever facility the Tata Motors is giving, the same facility is given to the.
This is not the same thing. This is not the same thing. Somebody wants to go to Vedanta Delhi for a treatment. If you have a tie-up, you will go. I'm just trying to. Next paragraph, number 2. Bharat Caterers.
He got letter as well. Unfortunately, it has not been annexed with the.
आपको ये सब documents हम देख नहीं सकते.
जो पैसा का record है जो खर्च हुआ वो है.
Tata
Tata Motors has given. Next your
Next reason, Bharat Caterers and Canteen संचालन.
एक कैंटीन संचालक है जो टाटा मोटर्स अस्पताल के अंतर्गत कैंटीन चलाने का कार्य करता है. भारत कैटरर्स टाटा मोटर्स का कोई अस्पताल का कोई अंग नहीं है. अतः टाटा मोटर्स अस्पताल के साथ कॉन्ट्रैक्ट समाप्त होने की स्थिति में कर्मियों का भविष्य पूरी तरह से सुरक्षित हो जाएगा. So to that I have my reply is that since 77 it is there, still it exists, and all the employees concerned, they have retired and now the ESI.
No, all the employees concerned who have retired, are they still entitled to all the benefits which is otherwise available in ESIC? Because they say that the benefit is available till death. Retirement is not material.
Yes.
And they are one of the reasons in one of the cases I was seeing that according to you, your employees are entitled only till the age of 75.
Yes, in one case it is there.
In one case it is there. I've read all the impugned judgments, impugned orders.
Perhaps.
If they have retired, how does that make a difference?
May I just say one additional thing? Perhaps the impugned order, which is signed over here, is 12/11/2015,
Yes.
and the annexure which my friend is referring is of a subsequent date.
Which is not the same impugned order. What is that?
Annexure 26, page 176.
हाँ ये तो अलग है. ये कौन सा impugned order है? This is not the impugned order. Yes, it is not the impugned order, madam. This is not the impugned order. This is not the impugned order.
ये 6330 2015
आज मेरा दिन बहुत खराब.
My clerk-
Everybody is wasting my time.
I have brought down-
Your clerk will decide what is the impugned order.
By name, he has brought this point.
Very good. Your clerk will decide. It means that you have also not gone through the impugned order at home. Because you do not know what is the impugned order.
Connection 26. आवेदक कंपनी चिकित्सा सुविधाएं केवल टाटा मोटर्स अस्पताल के माध्यम से उपलब्ध कराता है एवं इसका अपना कोई मेडिकल इंफ्रास्ट्रक्चर नहीं है और किसी अस्पताल से टाई अप नहीं.
These 1 and 2 we have read. This one we have read. Now number 2. Number 2 cashless सुविधाएं नहीं. ये क्या reason?
कैशलेस ट्रीटमेंट नहीं मिलता है एम्प्लॉयज को.
कहीं भी ये जाते हैं तो
इनके जो एम्प्लॉयज उनको कैशलेस नहीं मिलता है.
You are not entitled to cashless.
I am entitled to all the benefits what Tata Motors employees get.
Cashless.
Cashless also. कहीं भी जब हम कहीं जाते हैं कराने चेकअप तो कैशलेस ही हमको.
कहाँ लिखूं? And you have said that they have all retired. Two things are very important because they are under the ESIC, they are entitled to benefit for the whole life. So
And-
retirement is immaterial.
And the dependents also.
And the dependents also are entitled. So retirement is absolutely immaterial. And this cashless, where do you say that they get cashless facilities? Your service benefits are also not same.
Dependent benefit is there, sickness benefit is there, extended sickness.
Whole life का पहले benefit for the whole life. You see, madam, if you are granted exemption, then your employees will be disentitled from getting any treatment from ESIC hospital. So therefore, it has to be matching.
Yes, they are getting or not, after retirement they are getting or not. Cashless is there, tie-up is there.
Show me from the records, madam, instruction से क्या बता रहे हैं? These are the 5-6 reasons in the impugned order. You show me from your record that this is incorrect.
I'm just. After retirement, benefit is not there, but other benefits.
That's the end of the story. If it is not there.
There's one statement of cashless, if I may just add, in running page number 50 of the writ petition. And we have denied this as misleading because no document or proof of cashless have been submitted. Page number 50, E.
case F also I'm reading, it will not be out of context to mention that same page F. Tata Motors Hospital has been granted exemption in the past with only one precondition, that benefits of treatment extended to employees at Tata Motors Hospital should be cashless, which they as well as Bharat Petrol are adhering to it in totality. Employees of Bharat Petrol also get some.
Where is the exemption granted to Tata Motors Limited on this condition? Which period they have been granted exemption for this particular?
Because Tata Motors for several periods they have been granted exemption.
And we have denied this paragraph.
Madam, I am telling you one thing. Don't argue on instructions. Argue on records. I am not used to hearing anything which is beyond the records. If you can substantiate it from the records, it's okay. Otherwise, I will not accept.
I will just take from the file.
You have not read your file. You are looking for instructions.
No, it is there in their file.
To whose file?
Tata Motors exemption. Tata Motors exemption, it is stated there.
You refer to your rate petition for a moment. Page 95.
Notified.
95.
It's the order in which the matter was pending for exemption
For which period?
for the period 2005 to till now 2014. This is the exemption for the period. Before that, all the matters, all the period were pending.
You see,
And
this is a writ petition of 2007.
7.
So in this particular writ petition, there is no question of pendency of your exemption application of 2014.
No,
This happened in 2007.
7.
What is the period involved in this case?
Yes, Your Lordship. This is the period 2006.
Okay. Then the matter was remitted, right? You come to the next
To
page.
decide the exemption.
You come to the next page. Page 98. It was rejected, right? Then you have another writ petition, WPC 2213 of 2009. It was also rejected.
It was
Remanded.
remanded.
What
because
happened thereafter?
thereafter it was pending.
It is still pending.
Still pending. For several periods, starting from 2005, the matter was pending.
From where do I get that this is pending?
I can give the detail.
Show me from the writ petition. You have annexed these orders. Where is the state? क्या करते हैं आप लोग? You are representing the state.
Not in serial 10 and 11.
And what about the other cases?
Other case not in serial.
Yes, what is this? Every year exemption petition is pending. And for every year they will file an exemption petition and then come to the court and say that it is pending.
But in some case, they have filed after the expiry period also.
So you reject it. Who stops you from rejecting it? You say that they have filed it beyond the expiry period. We will uphold your order. But you will not say anything. Why should we say? You keep the matter pending and create a burden on the court. Your officers behaving in this manner are themselves a burden to the court, to the system, and a liability. What is this? 2006 exemption matter is pending. And have you realized the amount? Recovery has been done. They are not bothered about recovery. So therefore it is pending. Recovery का notice दीजिए अभी आ जाएगा deed petition. 2006 से matter pending.
As stated in page 43, para G.
You are doing service to the employees. What are you doing?
I have not taken such with regard to recovery.
No, it is there. Just see.
There's an interim order that till exemption is decided, recovery should not be made,
Very good.
as was in the sitting case.
And by that time all the beneficiaries would die.
Page 53, it has been-
Page
53, para J.
जो पेंडिंग था सो हो गया. अब एक भी केस इसमें से रिमांड नहीं. That much I can tell you. You'll have a clear order. Either you win or you lose. I will not remand any of these matters, creating further burden on the system. Repeated remand करके हमको कोई शौक नहीं. ये तो हुआ annexure 14, no? What about annexure 16? What happened after annexure 16?
Also remitted to the department.
Did not pass any order. No order has been passed. Very good. Every year there is a separate year. We don't bother about it. What happened in previous year. Madam, you satisfy me with respect to each of the grounds. If you fail on one ground, your petition is bound to submit. Satisfy, cashless, satisfy kariye. What material have you brought before the authority? You have to show that the material was brought before the authority. We don't want any fresh material in this court. Right? Show me.
Just
What? Why pass over? You have to show it from the records, madam.
5 minutes.
5 minutes.
How much can data motor will be? Till then.
You know, every minute how much amount is being spent? Do you have any idea? You cannot argue on instructions.
No, not instruction.
Then, why do you need instructions? Whatever you have put on record, you argue. Otherwise, I'll see the records and pass the order. I don't need anybody. I'm enough myself. You finish it off. You finish off the hearing of this case. And we are not appellate jurisdiction. We are in read jurisdiction. So you have to show that the order is ex facie perverse. You know the scope of Sheshwaraj.
Only to the extent of cashless.
No, every point you have to argue. There are numerous reasons given. You satisfy me with respect to each of the reason, and you say that this material was placed before that.
One affidavit can I show?
Affidavit for what?
Affidavit filed by the union, your lordship, that what facilities are given and what they are willing to.
Where is the letter? That is a fresh material which you are referring to.
With the writ petition.
Where is it? Where is the letter of the union?
I'm just.
It's also 117.
117. Can I read it? It has been affidavit and they also, union
What is
also.
the date of affidavit?
31,
31
2015.
And what is the period involved in this case?
What it has been stated, just I want.
We will not bother about it. I will not take this affidavit into account to decide for a case which relates to the period prior to this.
And this is of the Treasurer of Telco Workers Union.
No, we don't bother about it. These things are not placed before the authority, and we are not going to entertain this.
No, they also made an.
It is beyond the
application
period.
for exemption. They also made. Their application was also rejected. They also made for exemption that we are getting.
They are not before
better
us.
facility and it is 21.
They are not before us. They are happy with the rejection.
One more thing I want to show. The chart is given with this the expenditure.
Page number. Page number, please. What do you want to show, madam?
Just I wanted to show that each and every benefits. Just the council of Tata Motors has given the chart. The same chart I have also annexed. The same benefit is given to the employee of the Tata Motors employee, because Tata Motors is the principal employer and we are working in the same hospital itself. All the benefits are same and except after retirement. That is different. Otherwise, all the benefits are same.
What about tie-ups?
All tie-ups also,
So
everything.
where do I get this?
For that reason only I wanted to just only for 1 minute I will just show it. Just
Where will you show?
from the recordings. Just for that. I will only for on that one I will show you.
इन्होंने कुछ लगाया है देखो.
टाइप्स का कोई लेटर नहीं,
हम बस एक बार
सिर्फ
जब
स्टेटमेंट है,
आप अपना बैठ के देखिए अभी हम इनसे पूछें. हाँ बताइए.
सिर्फ स्टेटमेंट है we have denied that statement.
Denied.
Lordship may just take up the entire statement is basically Lordship may take up page number 46 of the writ application.
46. Can you read it one?
This they have done parawise with regard to the employer. That is that the employer dated 12/11/2015 valid law as well as on fact both and is liable to be caught for the following reasons. First, patient is a bona fide contractor running and maintaining canteen service at Tata Motors Hospital for the basis of indoor patients, their attendants and medical staff in the shape of a diet so and so. The patient has been a bona fide contractor ever since the establishment of TMH in so and so, as initiated by so and so. I'll skip this. 3. While rejecting the application, Principal Secretary so and so has failed to appreciate that the Act requires for the making of medical services available to the insured employees and members of their families and does not require that employer must have his own hospital and medical infrastructure. The petition for exemption has been raised on the ground that the employer provides medical facility to his employees through Tata Motor Hospital, does not have their own medical infrastructure. The learned authority has further failed to appreciate that Tata Motor Hospital has been recognized by 2 SI Corporation as an important credible medical institution, and the SI Corporation itself has recognized TMH as a good hospital and is in the process of tie-up with the said TMH and has also
As in the process of tie-up.
but वो कभी नहीं हो पाया. TMH has
नहीं तो
denied.
प्रोसेस पर है ना, उस वक्त का तो रिजेक्शन हो ही जाएगा, जब हो जाएगा टाई-अप तब हो जाएगा.
जी.
भाई जब हो जाएगा टाई-अप तभी ना होगा.
जी.
उसके पहले तो नहीं हो सकता.
Lordship.
It is an admitted fact that there is no
Lordship,
tie-up.
this is with regard to ESI Corporation having a tie-up.
ESI को
Tata Motors as a good hospital and it is in the process of
And
tie-up and arrangement which this ESI Corporation wants a tie-up with this.
Definitely, Lordship.
Okay.
So the observation made by the learned authority that the petitioner does not have tie-up with an important hospital. A statement has been made, no document in support of any tie-up. There has to be a tie-up letter, agreement, something of that sort.
You read this sentence again, it is such a,
The learned authority has further
authority has
failed
further failed,
to
yes.
appreciate that TMH has been recognized to ESI Corporation as an important credible medical institution, and the ESI Corporation itself has recognized TMH as a good hospital and is in the process of tie-up. So basically, we also agree we are in the
Yes,
process of tie-up arrangement with the said TMH, and has also made arrangement with about 10 or 12 other big and important hospitals for treatment of insured persons. So this is with regard to mine,
that is, these are not connecting to their types.
definitely mines.
आगे
The
पढ़िए.
observation made by learned authority that the petitioner does not have tie-up with an important hospital. This full stop is correct, incorrect, nothing has been stated.
Next.
The second. Furthermore, from the order, it appears that learned authority was more concerned about providing security of service to the employees of petitioner rather than looking into the standard of medical benefits provided to them as long as they are in service. The ground for rejection appears to also that if the contract is terminated, the future of the employee will become insured. Future of the employees employed will become insured. The learned authority failed to appreciate that if the employer has his own hospital and if he desires to close his business, maybe a factory struggling in a lawful manner, then the employment will automatically come to an end, and then it is not for the authority to consider whether or not there was a service security provider, and hence it will not be a ground for rejecting the application. The continuity factor stands substantiated by Bharat Gators running TMH canteen for about 50 years, and that shows the continuous engagement of the employees. Insofar as this is with regard to continuity. Insofar as ground number 2 is concerned, the authority has observed that the employees of the petitioner were not provided cashless medical facility, which is wholly baseless, incorrect, and imagined. The treatment either at Tata Motors Hospital or in other hospital, if so required, made available to the employees on cashless basis. Employees are not required to make any payment to the hospital providing treatment, and the cost of treatment is free to the employees. We have denied this paragraph in our counter. No supporting document. It will not be out of context to mention that TMH has been granted exemption in the past with only one precondition, that benefits of treatment extended to employees at Tata Motors should be cashless, which they as well as Bharat Gators adhering to in totality. Employees of Bharat Gators also get the same standard of medical treatment at Tata Motors Hospital and elsewhere as are made available by the Tata Motors Hospital to the employees. Again, Lordship, we have denied this as there is no supporting document to substantiate it. Insofar as ground number 3 is concerned, the learned law authority has failed to appreciate that wherever required, the employer has provided considerable long period of leave to the employees on medical ground. 2 cases requiring prolonged treatment absenteeism from workplace were of sheets so and so on sick leave since long. Documents in this regard were filed by way of documented evidence which have been completely ignored. The authority also failed to appreciate the absenteeism from work on false medical ground, and as is prevalent in practice, results in absenteeism from duty causing bottleneck in production and lowering down productivity in production. So far as ground number 4 is concerned, the documentary evidence of extended and enhanced citizen review were filed by way of long established practice, and the practice of providing any benefit for a long time itself gets hardened into rule of law and does not require a separate necessary document dealing the policy. Ground number 5 is also the provision of material benefit is a statutory requirement, and the petitioner could not avoid extending such benefit to any female employees if and when employed and if and when occasion arose. As for the present, there are no female employees. There has been no occasion to give such benefit. The scheme of the ESI Act is not to compel the employer to employ female employees only for the purpose of extending maternity benefits. Ground number 6 is also based in that the provision of ESI Act was extended to the place of employment where the petitioner runs the canteen in the year 2004, and the application made from time to time so and so was made to hear all the applicants, making them analogous with the application so and so, but the authority did not consider the prayer for hearing of the application together and picked up the application only in respect of the year 2014-15 and has rejected it. That the employees through the union have also made application for exemption, but the union workmen were never noticed and never heard in consideration the application for exemption. Addition of the Honorable Supreme Court so and so was cited where the principle laid down by the Lordship of the Honorable Supreme Court that the question for the benefit of the employees are considered when the employees are invariably be made a party. It was their application, they never made a party. It was their application, it was not my application. They should have made a party. That in view of the specific provisions made in so and so, where liability of principal employer has been fixed to pay contribution from the immediate employer, in view of this specific provision, the authority should have noticed Tata Motors Hospital for proceeding in presumption, which is failed to do so. That the learned authority, while considering the application, failed to appreciate that the employees who are sought to be covered under the provisions of the Act are getting benefits on their work spot, whereas in case of their sickness or sickness of members of the family, they have to go to a long distance, about 20 kilometers, to a hospital in Aditapur to get treatment, not involving time but also involving considerable expense in the shape of transport and convenience. The respondent authority has not noted the claim of the case of the parties before coming to the conclusion as said. So in a nutshell, this is the only statement. No supporting documents have been given. We have denied all these statements for want of any supporting documents.
Only one thing.
My reply is that counter filed by the ESIC from paragraphs 28 to 35. Filed on 22/3/2022. Counterfeit on behalf of respondent number 2 to 4.
Yes. Para number.
28, my lords. It starts from para 28.
Yes.
29 would be relevant. This is with regard to tie-ups. That is statement made in para 47C is misleading. Admittedly, the petitioner does not have a hospital. Further, no type document has been brought to record to substantiate the arguments. Thereafter, 29/30, ESI Act is a social security relation caters during and post-employment too, with regard to retired employees. 31, again, no document misleading, no document is brought to record to substantiate the arguments with regard to the employees who have been given, LS to be given. 32, exemption was considered on something there is nothing to say that the petition and the Tata main hospital are same and similar in all respects. There is nothing to that effect. 33, 47 G2L are misleading, no document has been brought on record.
Yes, that's
47, we are given a list of hospitals whom we have got tie-up for cashless.
28 to 36.
Definitely. 28 to 35 minutes.
One thing just I wanted to ask. What I was trying to say, all the benefits given by Tata Motors to its employee are same that to the employee of Bharat Petroleum. And in that, it is a different case before leadership WPL 2199 of 2021, in which it is their order in which they have stated only 2 lines I'm reading. साथ ही कर्मचारी के परिवार को अवश्य जहाँ पे सुविधा के 2 चिकित्सालयों का चयन कर सकते हैं आवश्यक 2 चिकित्सालयों का एवं आवश्यकता अनुसार ESI अस्पताल एवं टाइप सुविधा हॉस्पिटल से इलाज पूरे भारत जबकि कंपनी द्वारा देय चिकित्सा सुविधा टाटा मोटर्स से अस्पताल द्वारा प्रदान की जाती है साथ ही कर्मचारियों को चिकित्सा हेतु रेफरल सुविधा कुछ स्थानों के लिए उपलब्ध है सो दिस फैसिलिटी
कहाँ से पढ़े
ये TMH का टाटा पिगमेंट्स वाला जो है टाटा पिगमेंट्स
आप अपना इस रिकॉर्ड का बात करिए केटरिंग सर्विस
they are the principal employer and I am getting the same benefit in the because I am working in the hospital itself and I am getting all the I have given the chart also when the concerned authority asked me
चार्ट से
this
नहीं
chart.
होता मैडम चार्ट तो क्या कोई चार्ट बोली बना दिया
नहीं जो चार्ट टाटा मोटर्स का सेम वही चार्ट मेरा भी हम प्रोड्यूस किया अथॉरिटी के पास ये प्रोड्यूस They asked me to give the
There is
comparative
no
chart.
tie-up. If you have to show your agreement with Tata Motors that yes, this facility will be provided to you. ऐसे थोड़ी होगा chart. And you say that benefit for females, there is no provision for benefit, maternity benefit for females because there is no female employee.
Yes, because there is no female.
तो जब आएंगे तब बनाएंगे उनके लिए.
नहीं तो रिटायरमेंट तक कोई फीमेल भी.
Madam, there has to be a rule. Female आए चाहे नहीं आए. There is no facility provided. No female will join your
We
organization.
have not
That
denied
is why you don't have any female.
we have not denied that we will not give. We said only that.
Denied it's not that. You have to make provision. Like we have to make provision for persons with special ability. Disability provision में करना होता है ना.
What I'm-
We need interpreter, we need so many things.
what I'm
We
trying-
will not wait for appointment of interpreter when he comes and then we will appoint.
that my reply is that I'm trying to explain that policy is already there of the employee of Tata Motors, and whatever facility is there for the employee of Tata Motors, this same facility, medical facility, is given to the employee of Bharat Caterers, being the principal employee, and they have been granted from time to time exemption for the same medical hospital medical benefit.
That's all.
For the same. So what I'm trying, just last my submission is that what I'm trying to say, I don't know whether I will succeed or not. Section 1.5, edition is kindly have a look to section 1.5. This is the establishment. What I have raised in my petition, just I'm placing it. Just you know, the petition to be signed.
1.5.
Section 1, subsection 5.
To that, they have not given any reply, and as per my information and my knowledge, that has not been notified. The appropriate government may, shall I read it? May in consultation with the corporation, and where the appropriate government is a state government, with the approval of the central government, after giving 1 month notice of its intention of so doing by notification in the official gazette, extend the provision of this act or any of them to other establishment or class of this establishment, industrial, commercial, agricultural or otherwise. So till this occasion, no notification has come as per.
For every establishment, separate notification is not required. It is already applicable. If they want to extend to other establishments, then they can issue a notice.
They have not replied to this.
We have replied para 18 of my counter.
18.
They have not got on record any
This
notification.
is what we have exactly said, Your Lordship. I mean, permitted to read. It is stated that the petitioner establishment carries on manufacturing activity with the aid of power and hence is covered under the purview of Employee State Insurance Act, and there is no separate requirement of notification.
So
That
last-
is the definition of active sector. That's all.
Lastly, I would just want to say that they have been granted the exemption from time to time, being the principal employer, and I am also the employee of principal employer is Tata Motors. So I have all the.
When you
facilities.
say that they have been exempted from time to time, where are those exemption letters for the period involved in this case? I just want to see the exemption for the period involved in this case.
They have annexed some of the exemption period letters.
Something, I just want 14, 15, no, this is 14, 15.
My lord, this would,
I just want 14, 15. I don't want the entire bunch.
and this petitioner's case would be different. He is a
Yes.
contractor,
That's,
not a.
we'll see that, but they say that they have been granted
On
exemption. Let me
Tata,
just have
it is
it.
regarding the medical facilities, so whether that facility is there or not, that facility we will see. All of them have not been brought on record, but some of them have been brought on record. That is case number 2199 of 2000.
Period, I just want one period, 2014.
1415.
I'm not concerned with other periods.
Your Lordship, 1415 of which it
This
will be
is
Tata
related to
main,
14.
Tata main hospital.
Well, let me, no, not Tata Main Hospital.
I'm submitting that.
Their principal employee, let me see that if that is also there or not.
This is also in dispute. Who is the principal employer? Is it Tata Steel? Is it Tata Works?
No,
or is
they
it Tata
say-
main hospital? They are very silent on this.
My friend has
Para
come.
4. They are very silent on this. This para 4. The firm of the petition is a licensed contractor and the provisions of contract so and so for the purpose of cooking, serving so and so to the indoor patients of Telco Hospital.
Telco Hospital. So it is Telco. Telco must be having the exemption
Let them-
for the period
Telco Hospital.
2014, 15.
Tata Motors has exemption, Your Lordships, from 2015, January 2015 to December 2015,
We are on 14, 15.
14, 15 also we have.
Where is that?
So it even have been-
Statement से तो नहीं चलेगा ना ऐसे.
No, no, I had shown that.
I want 14, 15.
Yes, yes. Lordship, may kindly come to. Lordship, may kindly come to page 41.
Mr. Das,
Yes.
I have to find out some ways that I can read records of another case in the record of this
I was
case.
not, my letterpress, I thought Lordship was seeing my.
I'm absolutely clueless. How will you read one case into another? There's a limit to which I can read it.
Who is the principal employer? That needs to be first ascertained.
That's
And
right.
then whether that principal employer, because this is a case of Tata Motors, Tata Steel,
देखिए, WPC number 6330 of 23. For the learned counsel appearing on behalf of the petitioner, Madam Rashmi Kumar.
1112 is there.
The learned counsel for the ESIC and state are also present. The learned counsel for the petitioner has submitted that the impugned order at annexure 26 is relating to the period November 2014 to October 2015. And each of the grounds rejecting the application for exemption from contribution to ESIC is incorrect. A reference has been made to paragraph 47 of the writ petition, wherein grounds have been raised to challenge each of the reasons. The learned counsel submits that the petitioner is a contractor
para 3,
the learned counsel submits that the petitioner is a
para 4, sorry. Page number 12.
partnership firm and is a licensed contractor for the purpose of cooking and serving diet, etc., to indoor patients of Telco Hospital and nursing homes, and to the employees of the hospital and for allied works at Jamshedpur. And the petitioner is not a factory, it may be an establishment. A reference has been made to the provision of section 1 within bracket 5 of the Employee State Insurance Act 1948 to submit that no notification has been issued in terms of that section to extend the provision of ESI Act to the petitioner. And therefore, the entire action of the respondent ESIC is ex officio without jurisdiction.
Can I intervene?
Yes.
It is there in the writ petition, this had been stated from 1/1/2015 to 31/12/2015, exemption was given.
To whom?
principal employer,
Who is the principal employer?
Tata Motors.
Where do you say? The Tata Motor is your principal employer. The Learned Council has further submitted that the petitioner has been filing petition seeking exemption before the authority from time to time, and when the petition were seeking exemption were pending, one writ petition was filed in WPC number 351 of 27, which was disposed of on 2/3/2007, stating that the petitioner's application was still pending before the authority, and the matter was remitted to the Secretary, the Department of Labour, Employment and Training, Government of Jharkhand, to consider the application for exemption. Pursuant thereto, an order rejecting the application seeking exemption was passed by memo number 364 dated 31/3/2009 within bracket annexure 15, which was challenged before this court in WPC number 2213 of 2009, which was disposed of by order dated 24/11/2011 within bracket annexure 16, and the matter was remitted back to the authority for passing fresh order in accordance with law. She submits that it has been mentioned in the petition that no fresh order was passed. However, the petition seeking exemption for the period involved in this case,
November 2014.
November 2014 till
October 2015.
October 2015, has been rejected by the impugned order. The Learned Council submits that the petitioner is enjoying, the employees under the petitioner are enjoying all the facilities which are available to the employees of Tata Motors. That is Telco Limited. Correct? The Learned Council has further submitted that the principal employer of the petitioner is Telco Limited, and since the employees are enjoying all the facility, therefore it cannot be said that all the facilities, and therefore the exemption granted in favor of Telco Limited is also in case of Telco Limited is also applicable to the present petitioner. She has submitted that this aspect of the matter, if taken into consideration, would show that the impugned order is expressly perverse and cannot be sustained in the eyes of law. The Learned Council has referred to which paragraph that for this period they were exempted, which paragraph of the writ petition. The Learned Council for the petitioner, upon a query of this court, has not been able to refer to any paragraph of this writ petition to show that even Telco Limited was exempted for the period involved in the present case. The learned counsel appearing on behalf of the petitioner has further referred to an affidavit dated 3/12, 3/2 and 3/12. Affidavit dated 30/1/2015 as contained in Annexure 20 and has submitted that even the union has
Annexure 21.
Annexure
20.
21.
Start from 21.
Annexure 20 is 117, which is the affidavit of Shamsher Khan.
Yes. And 21 is the letter.
I am just referring to 20, then I come to 20. Affidavit and has submitted that this affidavit would show that all the facilities are available, which have been shown to be not available to the employees of the petitioner in the impugned order. Thereafter, she refers to Annexure 22, which is a settlement arrived at between the management of the petitioner and their workmen engaged in canteens located in Telco Hospital.
Before that is 21.
20,
What?
page number. Okay. Then the learned counsel then refers to the application filed by the Telco Workers Union to the Principal Secretary, Department of Labour, Training and Employment, wherein they had also filed an application to grant exemption to the employees under Section 88 of the ESIC Act for the period from 1st of November 2013 to 31st of November 2014, which is a letter dated 29/1/2015. The learned counsel submits that the application filed by Telco Workers Union was rejected without giving any hearing. However, the Telco Workers Union is neither a party before this court, nor the order of rejection in the application filed by Telco Workers Union has been placed on record. What is Annexure 22?
It is the agreement, right?
It is a settlement between the management of Bharat Caterers and their workmen.
And the union.
Minus.
And she refers to Annexure 22, which is a settlement arrived at between the management of the petitioner and
Their workmen, it is written matters.
their workmen engaged
In Telco
in the canteen located in Telco Hospital, represented by Telco Workers Union. And has submitted that the Telco Workers Union, having represented before the authority with respect to the employees of the petitioner seeking exemption for the petitioner, the party should have been noticed and then the order could have been passed. This is a settlement dated. Any clause in this settlement are you referring? Or it is just a settlement?
The settlement on various points.
Any clause regarding medical facilities?
No. Medical is not.
However, during the course of argument, the learned counsel for the petitioner could not point out any clause in the settlement relating to any kind of medical facilities which are the prime concern of the respondent ESIC in the present case. That's all. The learned counsel appearing on behalf of ESIC has submitted that there is nothing on record and not even a statement that the employees of the petitioner are the employees of Telco Limited. And therefore, exemption, if any, granted to Telco Limited has no bearing in this case. The learned counsel has then referred to the counter affidavit and has submitted that each of the grounds mentioned in paragraph 47 of the writ petition has been specifically dealt with in the counter affidavit. In paragraph 28 to 35 and have been denied, and such statement made in the writ petition is neither based on any materials placed on record nor any such material was placed before the authority. It is not the case of the petitioner that such materials were placed before the authority and the same has not been considered. The learned counsel has then referred to paragraph 8 of the counter affidavit to submit that the petitioner is covered by Factories Act as they are using power. Under such circumstances, there is no need for issuance of a separate notification under section 1(5) of the ESI Act. He submits that the argument of the petitioner on that basis that the entire proceeding is without jurisdiction is not sustainable in law.
One more, the admission that now they are paying contribution.
The learned counsel has also submitted that the petitioner is now paying contribution to the ESIC with respect to those persons who are covered under the Act. The learned counsel for the petitioner does not dispute this fact that as of now, the petitioner is paying contribution to ESIC who are otherwise covered under that, with respect to those who are otherwise covered under that. That's all.
Just one judgment with regard to judicial review.
Those judgments will be there because you have cited those judgments.
Definitely.
Those judgments and
case
your
to case
preliminary
basis.
objections that will be there.
और केस टू केस बेसिस में बोलेगा इसमें से जुडिशियल रिव्यू का जजमेंट होगा तो that's not completed.
Only one because this has been implemented since 16, so now after retirement that benefit that will continue by ESI, and before that period,
After retirement, it will continue by years.
if they give contribution, some contribution is deducted by the employee and the employer. So if that is deposited, they can get some benefit by the ESI after retirement. They have retired in the year 2024.
So I don't know what.
So their objection that after retirement, that for that I'm explaining. And rest only I want to say that they have stated
How will
specifically
they get the benefit after retirement from ESIC?
for the period, the
The
period after.
period cannot be segregated like this. You have to give the contribution when they are in service,
Yes,
and then by virtue of that contribution, they get the benefit till death.
9 years, 8 to 9 years they have given. And only one thing they have stated specifically that we have to travel 30 kilometers with our own cost and go to the ESI hospital.
That's all. This is all. This is over. इसका कोई दूसरा केस है इस कंपनी का,
I need to check.
इस कॉन्ट्रैक्टर का? Is there any
But
other case?
there has to be
Case
one
or
more-
it is only one case?
There has to be one more case of Bharat Petroleum, right?
So it is not on the board.
भारत केटरर्स 6330 is भारत केटरर्स, right?
This is the present case.
इसके अलावा तो कोई नहीं है.
इस आज का बोर्ड में नहीं है, but there's another case.
I don't know. मेरे बोर्ड का
I'm not sure about that.
WPL है.
At some time they find WPC, WPL. I'm not sure about that, but there's a case of Bharat Petroleum. I'm sure about that.
नहीं ये इसका सीएम. Yes. अब क्या होगा? अब कब सुनेंगे बताइए? एक एक केस करके हमको सुनना पड़ेगा. It can't be like this. Your argument is over.
टेबल में थोड़ा सा आर्गुमेंट बाकी है. Just two issues.
When should I post it?
Friday should be not sure.
आप लोग दोनों मिलके
My only anxiety is Friday.
हाँ बताइए कब आप?
Monday.
Monday we have kept one case.
But as I understand, your lordship wants us to address individually.
Naturally, because individual, there could be overlapping, but there are individual facts. I mean, caterer का अलग fact है ना?
Correct. I have understood because I came with a different set of mind.
Yes, we also heard it in the different bent of mind.
So therefore my preparation was complete. So what
I
I then propose is not I'll make my own preparation.
See, each case में दो, each day में दो case अपना चुन के कर लीजिए.
So lordship may I suggest, Monday को अगर fixed है तो Thursday को रख दीजिए. Tuesday lordship is already fixed on matter.
Thursday को कुछ नहीं रखे ना?
Thursday lordship Tata Cummins का 2 matter, 4 matter. या Tata Pigment का कोई भी आप कर लीजिए.
नहीं है ना? आप बताइए आप कौन-कौन सा केस करेंगे? सीरियल नंबर बता दीजिए, वही हम लिख भी देंगे ऑर्डर.
This will help me, and we can keep it as Monday, Tuesday, Wednesday.
थर्सडे बोलते हैं. हमारा ऑलरेडी फिक्स्ड है.
As your lordship.
कुछ फर्स्ट अपील्स भी रहते हैं ना.
Lordship accommodates all of us, lordship. So
Lordship 13 and 20 ये है. 1 and 2 जो आज लगा है 1 and 2 कर लेंगे.
1 and 2 कंक्लूड कर लेंगे.
जी जी.
ठीक है. और भी यहाँ आपका है.
और
Only
भी
1
है.
and 2.
1 and 2
ये टाटा कमिंग्स के सारे केसेस
चार
कंक्लूड
है
करते हैं ना.
लेकिन
You are
चार-
appearing for all.
all these Tata Cummins
1 to 4.
1 to 4 है लेकिन lordship grounds अलग अलग दे दिए थे. तो दो हम जो common grounds है that will consume time, that will complete. If time permits, I'll do the other.
Okay. But we'll tentatively keep 1 to 4.
Wonderful.
Tentatively. Right?
Let us see, 4 में तो हम लोग dictation भी हो गया.
आज का list के हिसाब से lordship देखा जाए.
नहीं,
It is from there
4
only.
नहीं बोला. टाटा
Tata
कमिंग्स का
Cummins
4
है
केस.
1 to 13 and 20.
1 to 13 and 20. Post the remaining cases on next Thursday at 2:15 first case. Counsel for the parties submit that each case may be required to be argued separately, and therefore the Mr. Ikeda submits that he would advance his arguments for 4 cases. WPC 2354 of 2019, WPC 2794 of 2014, and WPC 3885 of 2022, WPC 388 of 2022, which may consume the second half.
Which may lordship एक चीज और clear थी. Serial number 6 में TML diagram lordship has already heard. शुरू में उसमें उसका concluding argument है.
आपको जो आप you choose whatever you want.
नहीं ये चार तो करेंगे. लॉर्डशिप शुरू में टेबल ड्राइवलाइन का थोड़ा सा बाकी है. क्या बाकी है? लॉर्डशिप नॉट फैक्चुअल एस्पेक्ट्स. लॉर्डशिप रेफरल एंड ये जो टाई अप वाला जो था, आई विल शो इट फ्रॉम द रूल्स दैट व्हाट माय लर्नड फ्रेंड सेज इज इनकरेक्ट. इनका जो रेफरल का ये जो बता रहे हैं हम लोग को सेम चीज उनका है, तो रूल्स में लिखा हुआ है.
You see, it has to be substantially same. Yeah, I'm not very much.
नहीं सब्सटेंशियल नहीं हम लोग का जो रिजेक्ट हुआ लॉर्डशिप रिकलेक्ट.
I've seen that.
टाई अप बोला कि हम लोग का
That
टाई
is
अप
not a very good ground.
that is not a
of rejection, but whatever you have to submit.
Yes, I'll show it from the rules also. What my learned friend wanted to show and attribute to us, that is their rules also. They will also have to refer, otherwise I cannot.
And also serial number 7, right? The
Number
PA
6.
2199 of
2199. Yes.
2199 of 2021. उस दिन जो एक एक ग्राउंड पे आप लोग दो लाइन का एक नोट बना के लेके आए.
जी जी ये चार का अलग से नोट है.
Mr. Indrajit Sinha is free on that.
The order needs correction.
Which one?
The order which you lordship dictated. Mr. Ikeda senior.
हाँ, mistake it was. You see, Mr. Sinha, senior हम लोग थोड़ी decide करते हैं.
No. But what is a fact is a fact.
The fact is that the juniors decide the seniors.
So I am deciding this.
You are deciding that. Yes, Mr. Ikeda, senior advocate.
This is all subject to him giving us a party. One for his acceptance, one for our rejection.
Not rejection, postponement.
Whatever.
It's just a matter of chance.
That's all. Next. So we'll fix the next dates. When I have 3 companies to represent, we'll do 1 company each on the next.
That's नहीं उसी दिन सब रहेगा.
सारे कर देंगे.
लेकिन ये 4 केसेस का हम लोग को थोड़ी. I don't have anything to say on this, but Mr. Das, I really congratulate you for this, and I wish you all the best. And we had always seen you as a senior only. You have a team of junior. It is just we have declared it now.
Grateful you know.